Good afternoon, everybody. Can you hear me? Hello, thank you for coming to the ADC Howell seminar. You've seen the entire title. I'm not going to read it to you. First of all, I want to let all of you know that this is part of our annual education list of seminars that we do basically on an as-needed basis. We look, among other things, at what's going on our website, what kind of experts are people asking for, what is the discussion about things like motions in limine. And over the last few months, the issue of Kaiser liens has come up in a lot of our email requests, both for experts, motions in limine, and general discussions about what do you do under these circumstances. And so what we hope this is an answer to some of the questions that have been raised by our membership, and that really is a goal of ADC in its education, is to try and come up with seminars that are timely and address the needs of our membership. We hope this does that for you. I'm very pleased to introduce a panel of very respected individuals in the area that they will be discussing today, including, first of all, Tammy Rockholt, who is a registered nurse consultant by practice, has 20 years plus practice in reviewing and auditing bills, and is qualified as an expert in 6 different states, including California. So she's done this a lot. She's been in the trenches. Mr. Rosenbaum, who is at the other end of the table, is an ADC member, a partner at McDowell Cotter, and he's a litigator who defends carriers, private and public entities, has done extensive defense work in personal injury matters, has spoken on the topics that will be before you today on many occasions. And in the middle is Shauna Thomas, who had 25 years of civil litigation experience. Like Dave, is an accomplished litigator in her own right. She speaks very often on this topic and similar topics, has a great deal of understanding of Medicare liens, Kaiser liens, and how they impact trial and recovery by plaintiffs in those cases. Ms. Thomas came highly recommended, as did the other two, by numerous sources. So we feel like we've got a really good panel for you today, and I'll stop talking and let them start presenting. Thank you very much. Oh, I'm sorry, before we begin, I wanted to thank Liberty Medical Legal for sponsoring this event. Thank you.
Thanks everybody for coming. You've got your materials. We will not directly refer to them. We'll bounce back and forth to give you an idea, but I'm not going to repeat. We're not going to repeat exactly what's in the materials. So I want us to get in the framework of what we're doing today, and the starting premise is actually not Howell, but it's Kornbaum, and what we're going to talk about today. So the essence of today is that damages for past medical expenses are limited to the lesser of the amount paid or incurred for past medical expenses and the reasonable value of services. So depending on how we look at things, we're trying to get the lesser of those two numbers. Just as an introduction, we're going to start off and we're going to tell you a little bit about who we are and what brought us to this topic today. So Tammy, can you tell us a little bit about your background, please?
I'm a nurse, and I've been a nurse since 1977. I love what I'm doing. Due to some unfortunate circumstances years ago, I had to figure out what a nurse can do with years of experience in the hospital setting, and I could not do clinical nursing for about 6 months. I was disabled. And I found out that I had to audit my own hospital bill, and lo and behold, it had an error. It was in the favor of the treatment provider, of course, and that same provider, years later, is doing the same error. I call it accidentally on purpose. So my goal is really actually just to make numbers right, make sure that everyone I do an auditing, make sure that what the hospital or treatment provider is billed follows the rules that are put out by the American Medical Association.
I'm seeing some hands in the back. Can you guys hear us back there, or do we need some higher volume on the mics? Okay, great. Thanks, guys. And Tammy, now your role presently is you serve as expert witness in many cases, right?
Yes, I do.
Could you tell the audience a little bit about what that role is?
Primarily, I'm doing a variety of different things. Can everyone hear me now? Okay. No? I'm not on?
Pull it closer, we'll get it taken care of.
You have to do this.
Okay, how's that? Okay. I do a variety of different things. One of the things that I do quite a bit of is I will have physician consultants, or I'll have physicians come to me. They're treating doctors, and they'll say that they're really tired of their bills being denied by different payors. So they will ask me, what am I doing wrong? And I will consult with them and look at what they should be billing. And many of them are billing some of their codes out at, like, I'm going to say the 15th percentile. Others are billing it out at the 95th percentile. And I will consult with them and we'll average out the fees. And usually most treatment providers have about 15 to 25 CPT codes that they utilize on a regular basis. So I will help them even them out. I have had many doctors tell me that I paid for myself within about 2 weeks to 3 weeks because of them not continuing to get rebuttals from different payors. The other large practice that I do is I'm also doing expert witness work for attorneys for both defense and plaintiff. What I like about what I do is the numbers are the numbers.
Shauna, what brings you here today and your interest?
Well, first of all, thank you everyone for being here. Can you hear me? Okay. I've seen some of you before at prior presentations, and some of you are friends and colleagues, so hello to everyone. Thank you for taking the time. This is a very important issue, and I'm here today particularly because I had a tremendous response to in the Howell ADC group. I assume most of you are members of the Howell ADC group. It's a tremendous resource, but I had a great response to an email I sent around discussing a Kaiser case I had in which Kaiser, which I still believe is a Part C plan, but they are contending that they are just regular Kaiser in this case. We'll discuss that difference later on. But they are claiming in their summary that they provide, I politely refer to it as pulling numbers out of their ear. And what they have done is claim that they have paid $91,000, but oddly enough, they have only billed $9,500. And they want $91,000 from my client. The case isn't going to settle. I'm starting now to be very aggressive in taking depositions of not only Kaiser people, but my other key issue, as you'll hear later, is I've noticed a huge uptick, and my colleagues in Northern California have noticed it as well, I understand, in lien providers being used even when beneficiaries or claimants, plaintiffs have insurance. And I've made this my personal goal to rid the world of this nefarious practice. And I'm looking for the right cases to take up, because I think that given the line of cases we've seen, most recently the Dodd case that David will be discussing momentarily, I think that we're going to be finding that with the right cases and the right preparation, we're going to be able to strengthen and expand Howell, and I'm looking forward to us doing that as an organization.
So my interest in the topic stems, as many of you have been to my liens presentation. I'm sure that if I asked how many people here have one of my marbles, I know Andy Weiss is sitting there and he always tells me he still has his marble. But between Medicare and liens, even in my liens presentation, the whole Hanif and Nishihama cases was always a theme at the end of the liens presentation, because in fact, those liens were the paid amounts or the incurred amounts. So that was where my interest began. And then actually I tried a case in Sacramento County at the beginning of the year, and it was an interesting experience because there was a hard-fought battle on the Howell. Plaintiffs wanted to present the full amount. I said to the court they can't present the full amount, and Howell and Kornbaum tell us that they can't even present it for the futures. The judge said to me, Mr. Rosenbaum, I don't like Kornbaum, and then promptly looked at plaintiff's counsel, said, that's the law, and so I'm going to grant Mr. Rosenbaum's motion to limit your damages. Well, the second part of that was they had a Kaiser bill in there. And I made a contention to the judge that this consolidated statement of benefits was not a bill whatsoever, and that the plaintiff was never had to pay it. She never received it as a bill. And they countered with, well, there's a lien on the matter. And the judge had not been to one of my liens presentations and didn't know that he was walking into the guy who can quote Civil Code 3040 ad nauseum. So we had a discussion on the record about Civil Code 3040 and how it's got this weird formula, and that you are presenting and misleading to the jury by presenting this non-bill statement of benefits. Well, one thing you learn as a trial attorney, when you're winning on something and you see you're about to lose, you stop talking. So at that point, I stopped talking. The judge did allow the consolidated statement of benefits to go in, and so that brought me even greater interest in what do we do with this Kaiser stuff. So that's what brings us here today.
I forgot something.
Go for it.
We're also going to talk about Medicare Part C and D reimbursement. You've all heard us talk about Medicare reimbursement in general. That will be touched on very briefly. But Medicare Part C and D reimbursement has become hugely important, and you're going to see a lot.
So the first thing I want to do is direct us to the sources. Obviously, case law and statutes. I put together in the materials on the front page, there's just general sources of law with basically a table of authorities, including some of the cases, well, the significant cases and the lien statutes. And then starting on page 2, what I did was when I was researching this, I just took quotes out of the cases and pasted them into a document. So it's a quick reference, if you will, with citations. Certainly it's no substitute for your own research, but at least if you're looking for something or a concept about write-offs or what to do about Medicare, Medi-Cal, you can at least take these topics and then dive into it. When we're talking today, the pertinent cases that we want to talk about are Howell. We all know Howell. I'm not going to go into Howell. Kornbaum, which takes Howell one step further and tells us that the future damages or that the paid bills tell us nothing about what the future is. And then a few cases that have come up over the course of time that are pertinent. So one is the State Farm Mutual Automobile Insurance Company versus Huff. Again, a case dear to my heart because it involves lien law. And basically what happened was the plaintiff received a recovery. The hospital wanted its lien monies back, and the plaintiff interpled the money and said, you go fight over this. The hospital just relied on the bill that it submitted, and the court said that the bill was based on their standard charges and is not an accurate measure of the value of medical services. I thought it was interesting in that case because the court also pointed out that the hospital had all of the records it needed to show that the treatment was correlated to the billings, that the treatment was related to the incident. All of those prove up issues that a plaintiff is going to have. They said, hospital, it's all in your records. You could have done it if you wanted. You didn't do it. And most importantly for our purposes, a bill from a hospital doesn't mean anything. Again, another case we're going to talk about a little bit today is the Luttrell case. And you need to know that what it does is it takes our Howell doctrine and it applies it in both the context of Medicare and Medi-Cal. Okay, significant because as we all know, Medicare and Medi-Cal pay at most 10 cents to 20 cents on every dollar of billed item. The newest case that came down and the ADC sent out a news flash on it is the Dodd v. Cruz case. I think this is a wonderful case. I was looking at it the other night. A judge, retired Judge Frizzell Shelton, and it said retired from Los Angeles County, but that's a unique name, and we used to have a Frizzell Shelton down in San Mateo County. I think Judge Shelton helped us make some new law again. At any rate, that case is very important because it is now opening the door to us for discovery. And it restates what we learned in law school. Discovery permissible if it's reasonably calculated to lead to the discovery of admissible evidence. And in our cases, that admissible evidence relating to the amount of medical expenses actually incurred. Okay, so this opens the door for us to do all kinds of, if you will, expansive discovery. And then there's a final case that's kind of critical for what we're talking about today. Shauna will bring it in more context as we get into the Medicare component. But there's a case called In Re Avandia Marketing. And essentially to that case, a third-party Medicare provider, they call them Medicare Advantage providers, United Healthcare, Blue Cross, Kaiser, they all provide this kind of simultaneous Medicare coverage. And basically that case said that those providers, although they're private, have the same rights under the secondary payer statute as Medicare would. The lien statutes, they're all listed here. Again, Medicare is one. HMOs, Civil Code 3040 is a really important one, and I'll talk about it in the context of the Kaiser consolidated statements. Workers' compensation. So it's a lien, but also it's important because there is a case that says that Howell applies to payments made by workers' compensation carriers, which again are set by a schedule. They're usually a lot less than the billed amount. The hospital lien statute, we just talked about it in the context of the State Farm case. And then again, Medi-Cal has its own lien rights, and there are limitations as to what the plaintiffs can recover for attorney's fees. We also know that Medi-Cal, again, pays about 10 cents on every dollar. So that's kind of the really important law that we want to keep an eye on. And again, it's in your materials. If you have a question, just refer to the materials and you can go and look it up. So we talked at the very beginning about this concept. We've got the incurred amount versus the reasonable value, which is the lesser. And when I was talking to Tammy earlier today, I was talking about this concept of reasonableness. And in my mind, whenever we begin to talk about reasonableness in any setting, to me, the red flag is expert, expert, expert. The reasonable conduct. In this case, the reasonable value. So this topic is reasonable value in experts' world. Let me set it up for you. Tammy's going to talk a lot about establishing the reasonable value in her expert opinion. She's going to talk about the charge master, I'm not even going to say it, she's got a great way to pronounce the acronym HCPCS, CPT codes, ICD-9s, and then the essence of what the experts do, which is finding usual and customary. And remember, usual and customary is not our legal standard, right? We're going to translate usual and customary into reasonable value. So why do we need experts? Well, in Dodd, it was very clear. They said a qualified expert may opine on the reasonable value of medical services based on matter, remember, whether admissible or not, in other words, reasonably relied upon by experts in that field to present the information. So that brings us to people like Tammy. Tammy, tell us what you can tell us about Charge Master.
What you see here is actually a picture of Charge Master. This is something that, can everyone hear me okay? Okay, this is something that a lot of attorneys are not even really aware of. There is some explanation actually in your booklet on how to use a Charge Master. And it starts with, it's kind of broken up a little bit, but it's on pages 74 and 83. California is really good because what it has is every hospital in the state of California has to put what their prices are, from a price of ibuprofen to a CT scan of the abdomen to a chest x-ray to their room charge for med-surgical to ICU, etc. And every hospital does this. Where I find, and I don't like to say accidentally on purpose, but what I am finding sometimes is some of these personal injury cases, there seems to be different fee schedules. And there's a different fee schedule utilized when a claimant has auto insurance or commercial. It's like a slip and fall. And so the first thing I will do, and I know I've worked with Lauren at Safeway quite a bit, is that I will look at a few high price items on the Charge Master of that hospital. If the Charge Master items do not sync with the itemized billing, then I talk to my counsel and I will say, you have grounds to say that this is not a legitimate bill. Because all I'm doing is comparing what the hospital has actually put out on their Charge Master versus what they have on their itemized billing. Yes. Okay. So what I think is really important about this is something that you can do on your own or have your paralegal do. And so I take that first step. And then the second step that I do with the Charge Master is I will also look at what they have charged for, I'm going to say, for instance, a chest x-ray. I will look at what they've charged for a chest x-ray, and let's say that we're using here in San Francisco. I will pick 4 hospitals here in San Francisco and do a comparison of what 4 hospitals in this geographic region charge for, i.e. a charge for a chest x-ray, and do a comparison. That seems to be very powerful at jury trial, or to show that, I think you were talking about pulling it out of your ear. I call it rolling the dice, like in Las Vegas, like what I was last week, and seeing what number you can. ChargeMaster to me is not a reasonable cost, but it gives you a starting point of what the hospital has put out that they are going to charge. So when you can find out, number one, when they have not number one, done what they said they're going to as far as the billed amount, then you can show issues with the bill. And then number two, you can take it one step further and do a comparison.
Question.
Yeah, this is a problem that I ran into because I was trying to reconstruct Kaiser costs and been able to get them out of discovery for a hospital stay. And the difficulty was coming up like, what is a day at Kaiser cost? You know, all those incidentals that go into the entire cost of the hospital, you know, the surgery is a fraction of it when you look and you're trying to reconstruct what the entire cost of the whole stay and all the services provided are. I'd be interested in knowing how you address that.
So let me just restate for you in the back. This individual here has looked, she's trying to figure out using a charge master what the total cost of a day in Kaiser is. But when you look at the charge master, you're not going to get one day. It's broken up by the individual item. So the question to Tammy is, how do you figure out using the charge master what that cost is for a full day, if you will, in the hospital?
David, do you want to first explain what you did last night with the Kaiser ChargeMaster?
Great. So thank you for the segue. So last night when I was putting together these slides, I decided I would go and check out ChargeMaster, and it's real easy. You go to California, type in ChargeMaster in Google, ChargeMaster California. In fact, this is the screenshot from my machine last night. I put in the name Kaiser. It turns out Kaiser has numerous different Kaisers in the state. Fancy that. And you get a list below it, and the list is a series of spreadsheets. And if you click on that spreadsheet, within the spreadsheet, you get the items that they have. Now, the one I happened to pick had, I think, 7,720 something entries on it. I was looking for the classic ibuprofen because we all know that when we've seen hospital bills, it's amazing how much they charge for that simple little pill that you can buy at the pharmacy for, you know, a penny, and they're charging $10. So I went into the search field in Excel, and I typed in ibuprofen, and I got my one hit. So that's kind of a way it is. But why don't you say how you do it?
Okay, what I'd like to do, first of all, it depends whether or not, have you received a bill from Healthcare Recoveries?
No, what this was we knew that for a bunch of office visits, we had records of every procedure that was performed in hospital stay, but none of it had charges for each itemized thing. So we tried to reconstruct it using the charge master. I assumed that office visits would be charged, all this kind of stuff. When we finally got an itemized inventory, you know, after discovery bills and all that sort of thing, it turns out it's totally different. And so that's what's hard, you know, if you have a CPT code or something like that, you can go, okay, ankle surgery, but, you know, the hospital stay, all of that is the stuff that's hard to reconstruct, and it's a significant portion of the expense.
Okay, what I find is what I have heard from many, many attorneys and claim reps, it's sometimes can take 6 months to a year to get a bill from Kaiser, which to me is a statement of benefits. And I have been doing this for 15 years, and I would tell them face to face, I have never seen one that is accurate. So that's starting out. So, I mean, that's pretty bad averages as far as I'm concerned. But what I do is I look at what has actually been, if I do not have a bill, I will look at the medical records, apply CPT codes, and then run it through usual and customary. Because oftentimes you will want to come up with what a value for hospitalization is. And that's what I will do.
Tammy, when you say run it through usual and customary, what do you mean?
What I mean is there are different databases out there. There is one that I utilize. It's called Context for Healthcare. So when I say run it through a database.
Can I hold you? Because we'll cover that in a minute.
Okay.
So
Okay.
we'll get there. I do want to add one last thing about ChargeMaster, and this just relates back to Howell. If you remember Howell went to lengthy terms to talk about ChargeMaster in California and basically I mean, it supported its entire ruling on this farcical thing called Charge Master, which I think Tammy called it, it's the sticker price that you see on the automobile. It means absolutely nothing. It depends on who you're negotiating with, or in the case of a Blue Cross or any other healthcare provider, that's a negotiating starting point, right?
That is correct. I mean, I think I've worked at length with Jonathan Lee and Steve Toski, and they have both been great in helping me really realize that a price that a treatment provider puts out there is a starting place for negotiation. Most treatment providers, when they send out a bill, doesn't matter if it's a hospital or a treatment provider, they know that depending on who the payer is, they are going to be reimbursed anywhere from 20 to 60% of what they have billed out. And they are accepting that as full and final value.
Next slide is this HCPCS. How do you pronounce that?
HCPCS.
HCPCS. Can you tell us what HCPCS codes are and level 1, level 2, level 3?
This is a broad overview, and I think a lot of you have probably heard of it, but level 1 are the CPT codes. Everyone's heard of the 5-digit CPT codes that are from the American Medical Association. And then level 2 are the non-physician services like ambulance, durable medical equipment, prosthetics, and injections. And there is level 3 are local codes, and those are obsolete. And for any of you that are doing defense for both, i.e. workers' comp and personal injury, if a treatment provider utilizes the California workers' comp and California workers' comp is behind the times, I think they're still using CPT codes from 1997. If they bill it for a personal injury case, it is not accurate. So you would have grounds for denying it. What I think is really important is these codes are put out by the American Medical Association. And there's a caveat in the front of the CPT code book. Whenever I go to a jury trial, I will take a copy of the CPT code book with me, and I will say in the front of this book, and I will read it, if a treatment provider utilizes a CPT code, he or she is agreeing to the definition that is put out by the AMA. So when I get pushback from opposing counsel on, well, you know, how do you know that the code shouldn't be this or the code shouldn't be that, I can come back and I can quote it verbatim. And that's what I would always do at jury trial.
What does HCPCS stand for?
HCPCS. And that healthcare,
There we go. It's alphabet soup.
yeah, it's alphabet soup. And in your booklet, because there is a lot of alphabet soup in medical, and I mean, I'm the only person here, I think, except for a couple people that are non-attorney, but we have our own medicalese, but you have your legalese. But in your booklet, from the actual registry for Medicare, I have a definition list for you, and it starts on page 75, and then there was a little bit of a hiccup. I think the machine got really excited when they were copying, but the alphabet soup goes pages 75, 80, 81, and 82.
And it's the Healthcare Common Procedure Coding System.
Thank you. And what I'd like to say is I am going by the rules that the AMA puts out. I'm not making up the rules. State of California doesn't make up the rules. It's the AMA. And my first job after my ski accident was actually just looking at hospital bills for Blue Cross of Washington, Alaska, and making sure that what the hospital billed was documented, and then negotiating a settlement with the hospital CFO. And this one we come up to CPT codes and ICD-9 codes. Has everyone heard of CPT codes? Raise your hand if you have. About 3/4? Okay. CPT stands for Current Procedural Terminology, and that is on your list. And where I see a lot of issues, and this is something that Healthcare Recoveries for Kaiser does on an ongoing basis, as well as sometimes when I've seen a VA try to reconstruct a bill, is they will, I don't know if it's accidentally on purpose, but they will omit the modifier. And The CPT modifier is very important because you're going to find that you do not want to pay for a radiological code twice. A radiological code has two components, and the modifier has first the technical component, which is -TC of the taking, and then the second part is the -26, the professional. So what I will see oftentimes on healthcare recovery bills is where you are being double charged without the modifier for all of your radiological codes.
So I just want to direct everybody's attention. Shauna provided us in her materials, and it starts at page 22. It's a lengthy bill from Rawlings Company, and they were correcting me earlier today that you don't do CPT versus ICD-9. They're actually apples to apples, and we'll get there in a minute. But the reason I put it together was when I looked at this bill, I saw the ICD-9 code in one column, and I saw the CPT code in the other column. And so the CPT codes, it's a set coding of numbers, if I understand it correct?
5-digit, yes.
5 digits, and then the modifier, is that a hyphenated? Is it an extra digit? How does that work?
It's hyphenated, and it's usually a 2-digit code, or it might be a TC for like technical modifier.
And then are there different CPT codes for outpatient care versus inpatient?
Usually for inpatient care, like if a doctor is seeing a patient in the hospital, they are different CPT codes, but they are still a 5-digit CPT code.
But in terms of the ICD-9 code and what we will be seeing in ICD-10 codes, ICD-9 and ICD-10 codes are diagnostic codes. They are the conditions for which the patient has received the treatment. And when I discussed the EOB when Tammy mentioned that she's never seen one that's correct, I attached the EOB summary statement from Kaiser that I referred to in my opening comments, in which they're claiming to have, quote unquote, billed more than $91,000, but having paid more than $91,000, but only billed about $9,500. And later on in the materials, and we'll discuss this in a bit, I've provided Tammy's analysis at my request. My client authorized me to have Tammy review these records because I'm continuing to fight on every level with this, and I'm going to be taking the deposition of the Kaiser PMK in this and other cases to have them explain where they came up with these numbers. And that's going to be a subject we'll discuss at some detail as this presentation continues.
So Tammy, I walk into this and I see, frankly, I was confused. CPT, ICD-9, when we're comparing them, what's the distinction between a CPT and the ICD-9?
CPT is actually for the procedure. So let's say that you go into the doctor for your annual physical. He or she will bill what's called an evaluation management code, a 5-digit CPT code. If they order let's say they order some lab work, like a chem profile, a complete blood count, those are 5-digit CPT codes. But the diagnosis, the ICD-9 code, the diagnosis that would go along with that would be an annual physical. And one thing that I want everyone to be aware of is that we are marching towards ICD-10. How many of you in this room have heard of ICD-10? Okay.
Just a couple of hands.
Okay. This is really, to me, almost scary because ICD-10 is effective October 1st, 2013. And so that means all of our vendors, all of our payers, everyone has to make the transition. CMS, which is Centers for Medicare, is going to be doing some testing, and I'm really, really worried about it. But ICD-10, I think you're going to be seeing probably, I know right now there is a letter in the Wall Street Journal, and I can send that to you if you want, about fighting ICD-10. But I think it is important, even though it is going to cost treatment providers some money, they're getting federal grants for it, number one. But number two, we are the only civilized country in the world that does not use ICD-10 codes, the diagnosis codes. These diagnosis codes are spread throughout the world. I know that we're supposed to avoid the I word. I just want everyone to know that diagnosis codes are shared throughout the world, and they are actually right now starting research on ICD-11. So for United States to continue using ICD-9, I think is really not acceptable.
Well, what is the importance of using ICD-10 in terms of the fact that it's used throughout the world? What information is gathered from ICD-10 codes?
A lot of research, a lot of looking at outcomes. So let's say that an orthopedic surgeon in Germany wants to know the outcomes of different treatment modalities for a spiral fracture of the ankle. He can research ICD-10 and look at what treatments have been done throughout the world. So it's very, very important, and it's important for statistical gathering, and I think just for the United States to keep up. I mean, Australia, who usually kind of lags behind, they went to ICD-10 3 years ago, and Canada went 2 years ago. So I think we can learn a lot by their errors.
I'd suggest to our audience that what we're hearing is if we're happen to get medical records from foreign countries, this ICD-10 is a way that we can at least begin to understand maybe a foreign language that has been presented to us, if in fact it's part of the record. I can't say that I've ever seen it, but I never knew about this existence of this international standard. So again, a little takeaway for you is you happen to get records out of a country and you can't read them, well, at least look for the ICD-10s. You may be able to get some correlative information and at least report back to your client, this is what it looks like, what's going on.
And by the way, ICD-9 codes, ICD-8 codes, several iterations of ICD-9 and ICD-10 codes are readily available on the internet. There aren't very many differences, truly, between the ICD-9 and the ICD-10. It's essentially sort of tweaking a system that's already firmly entrenched. But they do take into account recent developments in medicine that are important for us to take into account, particularly because, and this is something you might want to keep in mind, since our focus here is on Howell and how Howell affects reimbursement of liens in various scenarios, you might want to keep in mind that very quickly now, if you receive bills that are billed under ICD-9 codes instead of ICD-10 codes, they're going to be rejected by the insurance company if the insurance company is doing its job properly, because the bills should be billed a certain way. Of course, insurance companies want to avoid paying if they can. I'm not saying that is a negative thing. It's just that they don't want to pay bills that have not been presented to them in proper form. And you're going to want to watch that, because there is, as most of us know, for almost every insurance company, in fact, I would say every, got on a limb, there's a time period in which the provider must submit a bill. To my knowledge, and with Medicare it's 12 months now, with most other insurance companies it's 18 months. You don't get extra time just because you do it wrong the first time. So if that time expires, you could well find yourself in a situation of being able to put on evidence in a motion in limine, Your Honor, this evidence should not come in because these bills were never processed by the insurance company. There was insurance, they were billed improperly, the insurance payment came back as zero. That's our Howell number.
Tammy, can you talk a little bit about the references you put up here?
Yes, I think it's very important that when you're evaluating your file, and this is something, if you have a paralegal that maybe is really specialized in this, it's very good, but you can look at the year of the HCPCS codes or the CPT code or the IC9 code. And this is really important because every year CPT codes do change. I think for 2014, there are like 522 changes. And some of the codes are new codes, some have different meanings, some are now obsolete. It is up to the treatment provider to make sure that they are billing for the proper code for that year. And so this is something that, depending on what year the treatment provider treated in, then I will utilize that in my billing and coding review. So if there's been a treatment provider that's billed in 2012, I would use a 2012 HCPCS level 2. And one thing about HCPCS is, I don't know if it's taught in attorney school, but I know in claims school, it seems like Claims Adjusting 101, they are taught, they owe for the ambulance trip and they owe for the ER. I am not saying that they do not, but they still have to be coded correctly. And right now, we just finished a big suit down in Texas, Dallas, Texas, where for 4 years, the city of Dallas was billed by the ambulance company for all of their transports being ALS, Advanced Life Support. That's a HCPCS code, and they should have been 90% of them being billed BLS, Basic Life Support. City of Dallas got a $60,000 refund.
Okay, so let's talk now about the essence of usual and customary. Talk a little bit about context for healthcare, usual and customary reasonable fee database.
There are many databases out there. I mean, all you have to do is Google and you will see a number of databases come up. When I'm vetting a database, the things I want to look at is how fair are they to the treatment provider? And what I feel very strongly about is if you're looking at a database, I want to make sure that their numbers are being evaluated on the amount that has been billed by the treatment provider, not the amount paid to the treatment provider. I also like, there's some databases that will have California broken into 4 geographic regions or 8 geographic regions. Context for Healthcare takes it out to the 3rd digit of the zip code, and so California has it broken into 31 geographic regions. So a doctor in Bakersfield is being viewed differently as far as the RVS from what Modesto is versus San Francisco versus Redding. I just had a jury trial not too long ago, and I was very surprised that prices for physicians doing business in Chico, their pricing is more expensive than what it is in Sacramento. So one thing when you're looking at opposing counsel's expert, if they just say that they look at the numbers and based on their years of experience, they know that they're okay, that to me is a red flag.
So Tammy gave us some materials at page 84 is something called the Oxford Outcomes Context for Healthcare's Usual and Customary Reasonable Fee Database review of methodology, but I really found interesting was the white paper attached. And I'll let Tammy speak, but I'll kind of introduce this a little bit. This Context for Healthcare survey of fees is a very methodical process by which they're taking baseline rates, they're looking at geographic regions, they're revising either up or down based on cost of living indexes to come up with pricing, right?
That is correct. And I think that if you read the white paper, this is something that I think is really good because there are some issues out there with databases, and some of them have gotten a bad rap. And there is one out there that I used 10 years ago and I will not utilize now because they were owned by an insurance company and they got in trouble with the state of New York Attorney General's office because they were pricing things that were not appropriate. So when you're vetting a database and you are, if you would hire me or we've got some standard questions, you want to look at what database the opposing expert is utilizing.
So when you're taking this Context for Healthcare or the other databases and we're trying to figure out usual and customary, I mean, kind of how does your testimony go in that flavor?
What I do almost all the time routinely is I will take medical records and I will look at if I see any, and I'll look to see what they have billed, and I will look first at any issues of upcoding or unbundling or duplication. And then I take my recommendations and let's say that a doctor has billed a 99205. For you that are familiar with CPT codes, that is an evaluation management code of high complexity. CPT, who puts out CPT?
AMA.
AMA, not me, not State of California, not you. CPT defines that a 99205, you are likely to suffer death or serious consequences. So it's not me saying that. So if a treatment provider has billed a 99205, and they have gone in after a car accident and their neck hurts and their back hurts, I will look to see, I'll look at how much, what they did in their evaluation and their decision-making complexity, and I might downcode it to a 99202 or 99203. One thing that I don't think a lot of you are aware of is there are classes out there on how to get $6,000 to $10,000 more per auto accident or work comp accident.
Classes for whom? Doctors?
Doctors. And I went to one, I was a doctor's assistant, and I had to sit on my hands and bite my tongue, but it was very, very interesting.
So the next step, you've downcoded. How are we getting ourselves to customary, usual and customary?
Then I will plug the price into that CPT code that I've decided that it should be into my usual and customary, and I go at the 85th percentile. And this is something that Shauna and I have had some discussions about, because when I'm going to deposition or trial, I want to make sure that I am coming across that I'm not just trying to cut bills. And what I find is that 85th percentile is making me look like I am very credible. I am also making sure that I'm just not cutting the bill. And what I like as well is that it goes out to the third digit of the zip code.
Go ahead.
Thank you very much. I just wanted to mention that Tammy has done quite a bit of work for me, as she has for Lauren, on some matters. And I have asked her to provide me with some additional numbers, some additional percentages, which is easy for her to do once she gets her initial analysis done. One of them is based on what hospitals will usually, what providers or what insurers will usually pay based on a percentage of Medicare rates. Almost everything seems to lead home to Medicare ultimately. But one of the numbers that I asked Tammy to provide me for now is a 200% Medicare rate. I could do that math myself probably. But that gives us another total to look at. But also, she mentions 85%, as David will explain. Under Civil Code Section 3040, in a capitated plan is only permitted to recover 80% of the usual and customary value. So if Tammy's evidence of usual and customary value is accepted, I've asked her to provide me with an 80% figure rather than 85%, not because I'm trying to in any way make her appear less than credible, but because I think that that's appropriate under the code.
Question.
In Sacramento, we have Shriners Burn Center, and we're trying to figure out where their numbers are because they basically provide services for free. Are they considered a capitated plan?
The question is Shriners Burn Center in Sacramento considered a capitated plan? Do you know?
They are not considered a capitated plan because all of their, like doctors do their fees at no service, at no charge. What oftentimes you will find, however, is that you need to come up with what a value would be, and sometimes opposing counsel might come up that this hospitalization should have been $250,000. And what I'm saying is I can look at the medical records and either, if it was an overnight admission, apply DRG. And one thing we have not talked about, and I think this refers back to what you were asking about how do you come up with a price. If you look at page number 92 in your booklet, this is actually something that you can download that will be in that's one of the references. And you can see that this one that I did for Shauna is actually Kaiser. You can see Kaiser Foundation, Riverside. I put in what the DRG number is.
What does DRG stand for?
Diagnosis Related Group. And this is something that most payers, thank you very much, David, it's alphabet soup. Most payers pay with DRG. They do not do itemized billing. And so one of the questions that I will oftentimes come up with is, why are you doing an itemized billing when you've been paid by a DRG? That's a question that I always like to ask. I always find it very interesting to find out what the answers are. But this DRG is specific for this hospital. So you can see that $13,897 for for those dates of stay is what Riverside Kaiser would have been paid for that stay by Medicare.
And this is the case where Kaiser wants $91,000. Now, in terms of the Shriners question, there is some information. This has to do with Medicare Part C and D plans. I've got a whole bunch of materials on it, and if you'd like me to send them to you, I will. But in essence, I found something very interesting as I was really digging into this for this presentation, that generally, as I will discuss, Part C and D plans have limitations on how much they can seek in reimbursement, and therefore how much can be put on the blackboard by plaintiff under the Howell analysis. However, if services are provided gratuitously, a gift, the limitation does not exist. So then I think you would be put back into the usual reasonable and customary value. We obviously don't want to leave it to a provider like Shriner, and believe me, I have no problem with Shriner. They do wonderful work. It's terrific. But we need to arrive at a value that's consistent with the value that we see in other facilities that do similar work in the geographic area.
So now I'm going to be the heavy defense advocate for your statement about Shriners. And if the statement to me is made that Shriners never generates a bill, that it never writes off, and I've been asked under Korenbaum to prove the lesser of the reasonable value of services or that which has been incurred, 0 is my number. Because even though these two over here might be able to create a reasonable value for the services, Korenbaum tells me I get the lesser. Now, the contrary to that, and the reason I talk about the write-off, if you look at page 3, I cited the case of Sanchez versus Strickland. And that's important to note because it says where a medical provider has, number 1, rendered medical services to a plaintiff, number 2, issued a bill for those services, and number 3, subsequently written off a portion of the bill gratuitously, the amount that is written off constitutes a benefit that may be recovered by the plaintiff. Okay, so let's get this straight, right? If a bill is written, if someone is billed, and later I say to my client, yeah, don't pay me, that's okay, all right, that's still a number that I could present to a jury. However, if the client comes in and I say I'm doing this pro bono, the number is 0, no matter how much value there is to my services. So, try it in Sacramento, see how the judge rules. Hopefully he rules against the 0 and you get your name published up there.
Now, David, I have a question about this because this seems, at first blush, there are 2 Sanchez cases, but Sanchez versus Strickland strikes me as being contrary to what we know Korenbaum to hold. Is the distinction that the write-off is gratuitous rather than pursuant to contract?
Yeah, exactly. I mean, the issue that we have in all of this, as Hanif and Nishihama started this whole thing, was if you have a prearranged discount, darn, you're going to make me use the word. The negotiated rate differential. We weren't going to use that word all day and see if you picked it up. But if there's a negotiated rate differential, that is to say that Blue Cross or whomever has said, you may charge $100, but we agree that we are going to only pay you starting at the $80, that differential is what's called the negotiated differential. That's the starting point. Okay? In your case, with the freebie, we have no negotiated differential. When you get to the write-off stage, there's a component that's been incurred. So that's the distinction.
I think that David makes an excellent point, but I think that the position I was expressing is not my position. It's what the
Go ahead.
It's what the C and D plan information from Medicare for 2014 tells you about what these plans will be reimbursed by Medicare or what they will be paid by Medicare. And I thought it was very interesting that they specifically carve out a different rule for gifted medical services. So I'm not saying that the issue is resolved. It's one of those things that we do need to resolve. And just so everybody knows, I was a big advocate for defining negotiated rate differentials, and they are the contractually guaranteed payment of medical expenses at insurer negotiated rates. That's what we're trying to get ourselves to today so that we can go into our trials and know exactly what lien amounts are properly incurred under Howell.
So I want to kind of bring this section to a close about usual and customary compared to reasonable value. Remember, the jury instruction does not say the plaintiff must prove the usual and customary rates. The jury instruction says the plaintiff must prove reasonable medical expenses. What Tammy does is she looks at what's usual and customary in the region and says that would be a reasonable number, not something that is excessive. You can't take what's in LA and charge the LA prices in Eureka. So that's where this whole dovetail comes, because the only code section I've ever seen that uses the term usual and customary is Civil Code 3040, when it talks about what a capitated plan can recover back on its lien. Does that make sense?
And I have one correction that I wanted to make, and I know, David, I apologize for interrupting. But when I was talking about ICD-9 TED codes, I think that I said something in a poorly phrased way. When I said that essentially there wasn't much difference from ICD-9, I mean in general categories of diagnoses and treatment. There have been some additions, but what's very significant about ICD-10 is that ICD-9 went from, I think, somewhere around 17,000 numbers, because I've got one book that has them all in it, and ICD-10 has something like in excess of 150,000, because they've really broken them down and gotten very specific. And I think it makes it much more, even though it means much more work, I think it means there can be much more specificity and ultimately, I think, consistency in the billing.
So what we're going to do now, you have a question? Lauren does. You know what? So the question is, the statement was, we're just about to start trial. Defense makes a motion in limine to preclude the VA doctor and probably the Kaiser doctor, the billing persons, based on their not having sufficient expertise to talk about it. The question then comes is, does this mean in all of our cases we're going to need to have billing experts? I will foreshadow a little bit. I come to that conclusion when I talk about Kaiser. So it's 2 o'clock. We get to take a couple of breaks in here. I just want to give you kind of some posting as to where we're going. The next two topics that I expect us to cover is we're going to talk about Medicare. Then we're going to talk about the medical care provided on a lien basis only. We'll take a break after that, and then we'll come back and we'll talk about Kaiser consolidated statements. So the only way I could keep you guys all here on a Friday was to take that cherry and put it at the end of the presentation. So we'll see you all back in about 10 minutes. Thanks. All right, guys. Looks like for the most part everybody's here. So we'll move back into this. Shauna's going to talk to us about Medicare. Shauna is a wealth of information. As many of you know, she and I have done the Medicare presentation 6 or 8 times throughout the state. Every time we do it, I learn something more. Shauna has developed a specialty in evaluating Medicare information for clients, in negotiating with Medicare for clients. People will call me and ask questions about Medicare, and they're having troubles getting a case settled, resolved, whatever it is. And I say call Shauna because she's got this stuff. She's specialized in it. She's got secret phone numbers to wherever they're located in Washington, D.C. or somewhere else where she can get a hold of people that might actually provide information. So we're going to let Shauna talk to you about Medicare, its application in terms of how I'll just address that. And then she's going to talk a little bit about the ABCDs of Medicare and focus specifically on Medicare Part C and D. And then we'll have a brief conversation between Tammy and Shauna about Medicare pricing. So again, remember, we're here about Howell and Korenbaum and the whole legion of cases. So when you're dealing with a Medicare case or Medi-Cal, the case you want, and it's in the materials, is this Luttrell case. And as the court said, because Luttrell's liability to medical providers for their past medical services is limited to the amounts Medicare and Medi-Cal actually paid, and if Luttrell's recovery from Island Pacific for past medical services must be limited to those amounts actually paid. Take that again in the context of reasonable value versus actual paid. I look at this, and as we all know, when you see the billed amount and then the amount paid by Medicare or Medi-Cal, it is probably a lot less than the reasonable value of services. So anyhow, Shauna, tell us a little bit about what I call the ABCs and Ds of Medicare.
Well, first I'm going to put some pressure on you, David, so you can be thinking about this for later. But during the break, it was brought up to me that when you so rudely interrupted me and would not let me talk about usual and customary versus reasonable value, that everybody is waiting with bated breath for you to address that issue and make that connection for us. So I wanted to make sure you knew that. But Medicare A, B, C, and D. And he's going to be really good, too. And so is Tammy. And I'm just going to sit here. Okay, Medicare A, B, C, and D. We all know of Medicare A and B is traditional Medicare. I have begun referring to it as traditional Medicare more often these days because the materials that are put out by Part C and D plans refer to it as traditional Medicare. Medicare Part C, as many of you know by now, particularly if you've been to one of our seminars, is Medicare supplement coverage. Used to be called Medigap, any number of things, but now the acronym, another acronym, as if you needed more alphabet soup, MS, for Medicare supplement, is used throughout the CMS materials. Part D is Medicare prescription drug coverage. These have become increasingly important in terms of defense handling and in terms of payment of liens, both in the pre-trial settlement context and after trial, because the Avandia case came down in 2012, reversing a prior Avandia case which held that Part C and D plans did not have the same right to seek recovery in federal court if their right to reimbursement, their lien, was not protected. The Avandia 2012 case made it very clear that those plans do have that right, and they are entitled to sue for double damages if their right is not properly protected. We must show that we, meaning the defense bar and our clients, have been duly diligent in protecting the interest of Medicare Part C and D plans in reimbursement of liens, if there are any. Just as traditional Medicare does not have to tell you it has a lien, you have to go to them and find out. The same is true in Part C and Part D plans. You cannot hold still and hope that they won't contact you or the plaintiff. I just had a plaintiff attorney in a case, a brief comment. Please be very careful about this, and the defense has to be driving this train, because the Avandia case also gave us another little present, thank you very much, by directing the attention of the government and of the Part C and D plans at RREs, responsible reporting entities, our clients, as the first stop on the reimbursement train. So unlike traditional Medicare, I'm sorry, I'm having a weird day. But unlike traditional Medicare, which generally, until they got us all signed up to Section 111, and they have easy access to RREs now. It used to be that if there was a problem with reimbursement and Medicare found out about it, they would go to the beneficiary or the beneficiary's counsel first. And then if the money's all been spent, which we expect it would, and if the plaintiff attorney says, I'm not going to do anything except move to Cuba, then what the government would do is then go to the insurance company or the self-insured entity. That's no longer the case under Avandia with regard to Part C and D plans. And I frankly think it's going to be the case with traditional Medicare pretty soon too, since they have us all nicely lined up like lemmings and tied to Washington electronically and having to report to them every quarter. So the defense needs to drive that train. My story is this. I have a case in which I'm handling the Medicare component, as I do for several clients. And I had been telling the plaintiff attorney for months, because we had a defense attorney on the case. I was not defense counsel. I just simply was handling the Medicare piece. The defense attorney said, or the defense attorney identified in medical records that there was apparently a Blue Cross Part C plan. So I always send an introductory letter, as David does. My introductory letter says, if there is a Part C or Part D plan, please be advised that my client will not be dispersing anything until we get a final lien from all such plans or letters from all such plans that they do not assert a lien, just as we wait for the final demand from Medicare A and B. This guy would not respond, would not respond, would not respond. We finally got the final demand, the case settled. We got the final demand from Medicare A and B. And I wrote him, and he said, okay, it's fine to pay that amount to Medicare A and B, send me the rest. And I said, I'm sorry, I can't. You know, I still need the Blue Cross information, or you have to get the process started so that we can find out if Blue Cross asserts a lien. And I'm sorry, I've been trying to do this for 8 months for you so we wouldn't have a delay at the end, and he wouldn't cooperate. And he actually said to me, he wrote me an email saying, do not ruin this settlement by interfering with disbursement. And I said, you know, I'm not ruining anything. I'm trying to help you here. And I've been trying to help you for months. Someone else has been willing to pay to have me make the phone calls and get the information. But the bottom line is the defense has to be extremely careful. My client was on the verge of cutting him a check for the amount of the final of the difference between the Medicare demand, Medicare A and B, and the settlement amount. And fortunately, because we're in close contact, I was able to get her to stop. She had forgotten about the Blue Cross component because he had been so uncooperative about dealing with it. But what I want you to take away from this with regard to Part C and D plans is twofold. First of all, the way Medicare C and D reimbursement works is that Medicare A and B pays these plans a certain amount, a capitated amount every year for the number of members that they have under AARP or HealthNet or Secure Horizons or Kaiser or whatever it is. And if at the end of the year the plan has not used all the money that Medicare has paid them, then the plan gets to keep it. If the plan is in the red, if they've had to spend more for medical care than the capitated amount they've agreed to accept from Medicare, then they just have to accept that. I guess they can stop being a Part C plan if they don't feel that that's comfortable. Their rates are adjusted upward from time to time. They're also adjusted downward from time to time, depending on what CMS feels is appropriate. But in terms of reimbursement, two things to keep in mind. Number one, if you see a conditional payment letter from Medicare A and B, and it used to be through MSPRC. As of February 2nd, that agency no longer exists. COBC and MSPRC have now combined. We now have more alphabet soup. It's the Benefit Coordination Recovery Center, and it will come on stationery entitled COBR, which is Coordination of Benefits Recovery. Anyway, they do the same thing, but it's no longer MSPRC. If I slip and say MSPRC, it's only because I've been saying that for 6 years, and it's likely that I will. But if you get an interim conditional payment summary or a final demand from or a final letter from Medicare A and B that says they have 0 claims paid, and you as attorneys who have seen the medical records and gone through them with a fine-tooth comb know that there have been bills and know that there has been payment made or should have been made by Medicare, you must immediately consider that there is a Part C plan involved. Now, David's going to be talking about the importance of some forms of discovery later, but and I will be talking about that as well. But it's extremely important, and I ask for it in my introductory letter, and I keep asking for it, and I have my attorneys do it if I'm not defense counsel, in written discovery, to get the front and back of every single insurance card that a particular claimant or plaintiff might have. Because it is shocking how many times the beneficiaries do not know what coverage they have. They think that Secure Horizons is their only insurance, and that therefore they're highly offended that we are making them jump through Medicare hoops. You obviously can't get to Medicare Part C unless you're already a Medicare A or B recipient, but that's something sometimes is lost. I've also found that plaintiff attorneys do not ask their clients these questions. They just don't think to do it. So we, as the defense bar, really need to be proactive about this, because it's our clients at the end of the day that are going to be on the hook for suits for double damages if there's a Part C or D plan in existence and we don't find out about it and we can't prove we were duly diligent. Now, one thing I want you to know before I talk about how much they are reimbursed is that if you are told repeatedly at deposition, in response to discovery, on the telephone, that absolutely the beneficiary, plaintiff, claimant takes the position that he or she never had Part C or D coverage at any relevant time. That would be from the date of the incident up until the date the case is actually settled or tried to a verdict. Then that's fine. If that's their position, unless you have evidence to the contrary, such as a copy of a bill saying Blue Cross, Medicare supplement, and in which case you know that they're just mistaken and you can't ignore that fact. There's a declaration that I believe is in the materials.
Should be, I'll check.
Okay. But it's available. It's a declaration regarding coverage under Medicare Part C, D. Please reach me. I'm sure that there's contact information somewhere in the materials, but I'm Shauna at sbthomaslaw.com. I'll be happy to send you all the forms you might need. But this declaration is very important. It's also very important to plaintiff's attorney, because what it does is provide, under penalty of perjury, evidence that we can all rely on to show our due diligence in attempting to discover whether there was a Part C or D plan whose interest we needed to protect. And the declaration, I've modified it now. It used to just be for Medicare A and B, but I've modified it to, I've just gone on, it's a Word document if you download it from CMS or from the MSPRC website, which is probably going to change names pretty quickly. But I just have added a C and a D to it. And if someone takes the position that they do not have and did not have C or D coverage at any relevant time, I have them check the C and the D and check the box no, and then sign the rest of it and give it to me. If I get that early in the case, I also make them go through that process again at the end of the case when the case is settled, because of course we all know that Medicare beneficiaries can add or drop Medicare supplement or Medicare prescription drug plans several times a year, and they do. So it's not due diligence in my view, and I'm kind of compulsive about this and I recognize it, but it's not due diligence in my view to get it once. I get it at the end as well, because sometimes there could be a period of a year or more between the time you might first be told no, there was no Medicare Part C coverage and the time the case settles. Now, how much in terms of Howell? What are you going to be looking for in terms of what the plaintiff attorney is going to be permitted to put on the blackboard if there's a Part C or D plan involved? As noted, if you see a 0 from Medicare A and B, you've got to start looking really hard for a Part C plan. You can ask the plaintiff attorney to do the work for you, but I find that they are not nearly as diligent as we are in many of these endeavors. Some of them are, and I'm not dissing our colleagues who are plaintiff attorneys by saying that, but I find that it gets done if they will give us a consent to allow us to contact the Part C plan, figure out where the subrogation department is. My office has formulated a plan for dealing with Part C and D plans because they have become extremely common in the last 3 years. In fact, CMS told me last week that in the last 3 years, the number of Medicare beneficiaries who have Part C or D coverage has doubled, and they expect it to double about on a yearly basis from now on, because everyone is discovering that there are things that traditional Medicare does not cover that they want covered. Okay, so you find out that there's a Part C plan, and you get a final lien from the plan. take a good hard look at it. Have the beneficiary take a good hard look at it, because you want to do the same thing that you would do with a final demand from Medicare. You want to make sure that all the care is related. And the beneficiary is usually the quickest one to say, wait a minute, that was my gynecologist, or that was my annual physical. That doesn't belong there. So they can handle that. But then one thing to keep in mind about Medicare Part C and D plans is, first of all, Medicare does not pay for prescription drugs unless you have a Part D plan. With regard to Part C takes the place of Medicare A and B, plus, depending on the plan, there is additional coverage provided. When it comes to how much that plan is entitled to be reimbursed, the plan is required to play by the Medicare A and B rules. In other words, as under the Luttrell case, they are not entitled to receive any more in reimbursement for services that would have been provided under Medicare A and B than Medicare A and B would have paid out. And again, that's a very small number, so we want to make sure that that's the number that we're getting. I'm questioning my Kaiser case that I've shown you, because the numbers are just all over the board, and the woman is 97 years old, and I find it very hard to believe that it's not a Medicare Part C plan. So I'm going to be taking the deposition of the PMK at Kaiser over this, because they can't explain what they've done. All right. Do look at the EOB, and you might need the services of someone like Tammy, because there may well be some services that would not have been provided by Medicare A and B. Additional home health care, for example, or services for which they might seek reimbursement and be entitled to some reimbursement, but you can't tie it to Medicare A and B, because those aren't services that are provided by Medicare A and B. So take a good hard look at that, and don't just accept that you're getting the number that you have to live with. If you see that there's care that you know would not be covered under traditional Medicare, and by the way, that's changing, so I encourage all of you under the Affordable Care Act, go look at what's covered under Medicare in 2014. It's different. They're covering a lot more things now and for a lot longer periods of time than they used to. But so basically, the amount the plaintiff is going to be able to put on the board is the amount that the lien holder actually can produce and show was related to the treatment they paid for. You're going to also want to check and make sure, if you do also get a demand from Medicare A and B, that there hasn't been a mistake and you're not being asked, or the beneficiary is not being asked to reimburse in duplicate, because that can affect whether they're willing to accept your settlement offer. So it's in your interest to look very carefully and frankly do part of their job for them, because you need to know whether that number is correct. In terms of discovery, I've already mentioned the declaration and getting copies of the front and back of the insurance cards, but I want you to know that it's extremely important that you try and work with the plaintiff attorney if you possibly can. If they won't cooperate with you, you have to hold firm and tell them that you can't disperse, because the risk to your client, I mean, I can't tell you how many times I've had people say, well, it's just this one time, can't we just do it and make it work? And it's a stupid little case, it's settling for $7,000, can't we just, well, you know, the penalty, it could be really potentially draconian. And so I don't like to see that happen to my clients. Yes, please do.
Since she's talking discovery, so again, let's get focused on the Howell component of it, because we're trying to get the smallest number possible. When it comes to Medicare and or so you got Medicare, when it comes to the private industries of the Kaisers or the Secure Horizons, the power of information is held in the plaintiff. So we've got to get that information somehow. As we know from Dodd, we can do some pretty good discovery now. When it comes to Medicare, I have a pattern discovery that I say to my paralegal, issue the Medicare interrogatories. They're about 22 interrogatories, and it asks if you've ever been a Medicare recipient. It asks if you've ever been Medicare Part C, Part D. It asks all of these questions. So we start trying to get that information early, and then get the subpoenas out. You may not get a statement directly from Medicare of what they've paid. You may very well, though, when you subpoena medical records, get billing records. Now, you have to be cautious of the billing records. I remember a case I had 3 years ago where I got billing records for 3 months, and of those, the first month reflected Medicare payments. The second month didn't reflect any Medicare payments, and the third month reflected Medicare payments. Medicare had been paying all 3 months. So the hospital records were not as complete as I would have liked. Okay, but there's your other source to see and make the comparison about what's been billed and what's been paid by Medicare. Issuing subpoenas, now that we see under Dodd, we can go and issue subpoenas to the third-party plans and ask them for their information. So all that power doesn't necessarily now reside with the plaintiff. This is a common occurrence. You're going to see lots of Medicare stuff. I have a case set for trial in 2 weeks. The plaintiff was 68 years old. She had Medicare. She has United Health, which is a Medicare supplemental package. And she paid a little bit out of pocket as well. So I'm dealing with all three versions of these components. With regard to how I've dealt with counsel, I said, look, I will agree with you as to numbers if you show me the support, because they were not willing to release the Medicare conditional statements. So number one is, tell me what you think your number is. Number two is, show me the support so I can at least tell my client that we agree on the number. I am still going to make a Howell motion, and they still believe, for some reason, that they're going to be able to show the full billed amount. But that's kind of the practical application of how we're working ourselves through the Medicare system. Now, as Shauna said, sending a letter right off. Remember, 99.9% of our cases settle, right? I send a letter at the very beginning of any case where you see someone who is 65 years of age. That is your bell. That is your red flag. That's when you write Medicare in red letters on the cover of the file. You do whatever you can on your computer system to flag it. And at that point in time, that's when you send a letter to counsel which says, we know your person may be a Medicare recipient, and we are not going to resolve this case by issuing any drafts until we have what their lien number is, and we prefer, and I'm going to ask you at the time I settle this case to write 2 drafts, one to Medicare and one to you, so that we can wrap up the lien. Okay?
That's absolutely can't say that strongly enough. It's absolutely true. And David, I think that I'll let Tammy take over with the next slide.
So Tammy, can you tell us a little bit about Medicare pricing, the databases, and these other things that you have provided us in terms of other sources?
Yes, what I think is really interesting and what I'm trying to do is give you some tools that you can work with yourself or have your paralegal do. There's a lot of databases, as I was saying out there earlier, and I gave you why I choose Contacts for Healthcare. If you want to talk to me off-site, why there's some other ones that I do not choose, I'm willing to discuss them. The PFFS.com, this is an inexpensive source for physician Medicare pricing, and it's something that I want to say is like $300, $400, and it's fairly inexpensive, but it gives you a lot of good information because, again, you're going to want to look at the year that the provider billed and the year that for PFFS. The third bullet, the Medicare PC Pricer, this is what you can download. This is what all hospitals' patient accounts will bill, is the next one, the http://www.cms. That's the one that will give you that actual DRG number that I showed you, the DRG number that is on page 92. I think this is really important for any time you have a hospitalization that you are looking at a Medicare pricing. So this is something that it doesn't just have to be Medicare. Everyone is aware that major health carriers out there will pay anywhere from 100 to 150% of Medicare. And if you want me to send you this to you, I can send this to you as well. And then we have the acronyms appearing in the Federal Registry. We've talked a little bit about alphabet soup. I just really want to reemphasize that the acronyms and what they mean are on pages 75, 80, 81, and 82. I think one thing that we touched on a little bit, Sean and David both did, was doing questions for the PMK or PMQ. And in your handout on pages 76 through 79, there are some actual questions that you can take tomorrow if you're going for a deposition of a PMQ or PMK. And I give a little bit of background about Kaiser, and then I come up with some questions. And then in italics, I have the answer. So this gives you some really strong questions. And I also have some questions that are just for regular PMKs as well as trauma team. If you have a trauma team where there's been $500 worth of damage to a car and there's, $35,000 bill. If you want that, let me know and I can email those to you as well. But these questions, what I am finding very interesting is the last 3 times that I've come up with questions that are specific for a PMQ or PMK at Kaiser, all of a sudden I've gotten a call from my attorney and said, this PMK or PMQ has decided that this is above their pay grade, and so they're going to be doing the deposition with the hospital CFO. So I'm still waiting for getting some of these answers. So I think some of them are really good questions. I'm really interested. If you do use them, let me know what the input is.
So I have a statement, and then I'm going to ask Tammy a question. But when we were readying for today's presentation, I had looked at the Context for Healthcare report, and one of the things that has become readily apparent to me is that as Medicare or as the federal government goes, kind of the rest of America is beginning to follow. If you look at Context for Healthcare's analysis, you'll note that their baseline analysis starts with what Medicare may be charging, and then they may ratchet it up 100% or 200% and then make adjustments for cost of living. But their baseline number is Medicare, and part of it is because Medicare's got a price for everything. I mean, it's its own charge master in a sense, yes. Right? What I wanted to ask Tammy, though, in the context of our Korenbaum quote at the beginning, in your experience, do you find that the actual incurred amount as Medicare incurred is greater or less than the reasonable value of the treatment?
What I find is a good portion of my practice is actually doing negotiations. And so what's very interesting, especially when I'm working with a plaintiff case, is negotiating with the treatment providers. And I will sometimes get calls from plaintiff attorneys, and I'll say, how did you get my name? And they will say they were on the receiving end of my work product, and they want me to negotiate the liens with the providers. Usually, I start out at less than what I have put down for the reasonable and customary. In fact, I start out way less, and then I am usually able to negotiate them with no problem at all. And I've actually had a couple cases at jury trial. And the other thing I will do when I'm actually prepping for a major deposition is I will call the hospital, and I have a great paralegal that works with me on my team, and we will find out what would the hospital accept as full and final payment for a DRG. And again, this is something you can have your paralegal do. As Patrician's learned a little bit, you've kind of got to figure it out. You've got to find the right person to call. Just finding the right person to call sometimes at patient accounts can be going through just a lot of voicemails and whatnot. But I think it's really important to find out what would the hospital accept as a cash payment. My husband was just in the hospital, and our out-of-pocket was 10%, and the hospital was out probably $4,000. I called them up, and we have great hospital coverage, but I called them up, and I said, would you accept $1,800 as full and final payment? And they said, oh, we can't do that. The next day, we settled for $1,900. How many of you know you can call the treatment provider, even on your deductibles, and get discounts usually if you are willing to pay for it promptly.
So what do you think? Medicare is cheaper than the reasonable value, or is the reasonable value cheaper?
To me, reasonable value is whatever a treatment provider will accept as full and final payment. And I usually will say that Medicare is cheapest.
Okay. Obviously, the reason I'm getting that is, and it kind of dovetails to a conversation I had with Andy Weiss earlier, which is at some point, why do we chase all of this medical stuff? As Andy raises, the more we chase the medical, isn't it, the more we're admitting that we got some problem with our liabilities and we caused it. But again, the question too is, we are all constrained by our clients with the money that we don't spend for them, right? They don't want us to spend extra monies where we don't have to. We need to be good stewards of their resources. So the reason I ask this question is we need to think if there's a Medicare involved, maybe it's good enough to just say that's the best number we're ever going to get. We'll take it. We don't need to go with an expert on a reasonable value.
And by the way, don't forget that in any Medicare case, if the plaintiff is represented, there's going to be a further reduction that could be a very significant number. Medicare is now applying its proper formula for reduction that is the formula under the code. And I had nothing to do with the fact that they've done this, but I did call and complain a lot about it because the formula actually is the total, let's say you have a settlement of $100,000. And the plaintiff attorney has a 33 1/3% contingency fee agreement. And on top of that, it's been a very heavily litigated, hard-fought medical malpractice case. A lot of depositions, a lot of costs. Let's say there's another $30,000 in costs. You take that 33 1/3%. Well, no, forget it. I said medical malpractice case. I don't want to do the math. But it's a significant case, and a lot of depositions. Well, you end up with about 60% being the relationship between the amount of the settlement and the amount of the costs. Medicare under 411 CFR, the codes that we've cited, must take that percentage and apply it toward their unreduced conditional payments and reduce them by that amount. I've had reductions as high as 82%. So it's very important, and it's very important for the defense to have that in mind when you're trying to persuade a plaintiff to accept your settlement offer. Now, I'm going to try and do something quickly here because I know that there's a...
Take your time. We'll move to the next. So any questions on Medicare? Remember, it's the cheapest number out there. Take it. Make sure that that's the one you're arguing in your Howell motion at trial. Work with counsel to figure out what that number is. Save your battle for the right battle, which is where they believe full billed amount, we believe Howell and Korenbaum.
And that's kind of gets us to the next topic that I want to ask everyone here to please do me a favor and get in touch with me because I'm really trying to build a coalition on this issue. I want to see depositions. I want to see everything we can pull together. And that is the topic of treatment on a lien basis when someone has insurance. I'm personally offended by this, and I'm trying to formulate ways of attacking it because we've all seen the plaintiff attorneys much more frequently now. There's a fellow in my neck of the woods whose Tammy has dealt with many times because he now has offices all over the state. I've had 15 cases with him. I've never seen one in which the medical specials that he incurs pursuant to lien are less than 6 figures. And that I'm talking to the most minor slip and fall. So what do you do when a plaintiff attorney says to you, we're going to put this big number on? Well, what I'm starting to do now is I'm taking the depositions, first of all. Oh, pardon me. Thank you. The goal is to present evidence that the plaintiff had insurance but did not use it. I want that evidence to come in during the defense case in chief. So I have begun to structure the discovery that I am targeting in the case toward motions in limine. And there's a reason why. The reason why that I feel that this is a worthy effort is there is, of course, the well-known affirmative defense of failure to mitigate damages. If a plaintiff has insurance and elects not to use it in favor of treatment which they are almost inevitably have received at the referral of their attorney, I do not know of any authority that states the collateral source rule should prevail over the ability of the defense to present the affirmative defense of failure to mitigate damages. And if a judge were to take that position to me in response to a motion in limine, I would take it up on appeal because I think it's wrong. Another analysis that I've been pursuing is that you want to look at the failure to mitigate damages. First of all, it's important to note that Howell does not prohibit mention of insurance. Korenbaum, a little bit iffier on that. But Howell specifically says, if you look at the headnotes in particular, that it does acknowledge that there's always a risk of mistrial if you do mention insurance, but that risk has to be weighed against the probative value of the evidence. And again, I think the analysis is, why in the world should the defense right to put on a very valuable affirmative defense like failure to mitigate damages fall in favor of the collateral source rule? So what we have to do is keep in mind that under KC 3930, the collateral source rule should not be employed to preclude the defense from putting on this key evidence. That's what I would argue. And there's a case cited, Poole versus City of Oakland, that holds that the rule of mitigation of damages comes into play after a legal wrong has occurred, but while some damages may still be averted. Of course, that's a basic statement of the doctrine of mitigation of damages, and I think we should be hammering it home at every time. I have several motions in limine prepared. They haven't had to be heard yet, even when I've been designated as an expert, because the cases have settled. But my arguments essentially flow from the fact that grave prejudice would fall to the defense if we were deprived of the right to put on evidence of mitigation of damages. And post-trial evidence on this issue is, in my view, completely insufficient because we know it's not mathematical. I can't cite a formula. I don't know anyone who can. But we all know that the reason the plaintiff's bar is so upset about Howell is they want juries to see the very large number because there is some sort of relationship between seeing a large number for special damages and a greater award for pain and suffering. And that's what they want. That's what they're concerned about. Under Howell, and many courts have tried this approach until Korenbaum came down at least, we were getting post-trial motions to reduce the special damages. Well, I consider that inadequate because, and under Korenbaum, I think we've got legs to argue against that approach because, again, by the time a jury has seen the big number, they've already arrived at a number for general damages, and a post-trial motion won't reduce the general damages. You can get the special damages reduced under Howell, but otherwise you're not going to get it. I also think we need to be prepared to threaten, essentially, the plaintiff attorney with a motion for new trial on grounds of excessive damages if the evidence comes in of the unreduced lien provider bill when there has been insurance. I think that they should be threatened that we're just going to make a motion for excessive damages on the ground that the damages did not have to be that great, and they were simply because of what I would consider bad acts on the part of the plaintiff attorney, certainly perhaps on behalf of the doctor, and perhaps with some knowledge of the plaintiff. If push comes to shove, then I would appeal. But all of this flows from motions in limine to, on one hand, try and get the evidence before the jury, again, under our case in chief, of the fact that there was insurance that was not used. Now, Tammy's outline is very helpful in this regard because I've started taking depositions of insurance providers as well as the lien providers. I mean, the insurance company people, the PMKs, as well as the lien providers. But first, I want to let David talk to you briefly about what he's been doing now that Dodd has come down with Form Interrogatory 4.1.
So I just want to remind us of that simple thing that the Judicial Council put together in the language of 4.1. Usually we're the ones answering 4.1 because we've got to identify our liability policy and the amounts and so on. But it says, was there in effect any insurance which you were or might be covered? And it says then, for example, medical expense coverage. Okay, if that doesn't speak to health insurance as a form interrogatory, I don't know what does. Again, the jury instruction says they have to show reasonable medical expenses. Okay, it's not rocket science to figure out that the term medical expense coverage may also include the health insurance. Dodd tells us that we have a broad avenue of discovery. It reminds us of our code of our civil procedure classes way back in law school of calculated to lead to the discovery of admissible evidence. And one part that I didn't quote at Dodd that I found very, very supportive is that it says, a court shall err on the side of allowing discovery. So this gives us some ammunition. Do you want me to talk about the RFPs and RFAs?
Yeah, sure.
Okay. So we've got our interrogatories. Well, let's also ask them to produce, in my mind, a copy of the insurance policy that they have or that they should have at home. Let's get a copy at least of the health insurance card so that we can see what they've got. Each time this person may say, I don't have it. If you can find out later, now you've really set them up for failure to mitigate. I would remind you also that when we look at emergency room records, typically any hospital record, one of the first intake forms says, what is the insurance? Sometimes it says self-payer, but other times, and more often, it either says their insurance or it may say someone who's the primary provider for the family, the spouse, the parent, what their insurance is. So we have ways to find that information outside of just these interrogatories.
And, by the way, Tammy's questions that she gave, one question that I find very helpful that relates to what David just said is that almost always when someone has had an injury event, their first care uses their insurance because they haven't gotten to a lawyer yet. Their first stop is usually the hospital or the emergency room. And I love asking them, well, how come you used your insurance at the hospital, but after that you hauled yourself 110 miles away to this lien provider and instead of being treated by the orthopedic surgeon who did your shoulder last year, who you seem to be really happy with? And that's an exact case that I had.
I was going to say that's not, my trial that I had just a few weeks ago in Sacramento was just that. It was the two plaintiffs the day following the accident. One went to UC Davis emergency room. The other went to see her doctor at Kaiser. The very next day, they both went to a chiropractor who treated them on a lien basis. 5 days later, each of them returned to their respective to UC Davis to see her primary care physician and the other to the Kaiser doctor. Now, the one who had the UC Davis treatment, she went back to the chiropractor for the next 4 months. So one of their comments, so there I was, and one of their comments was she couldn't afford it. Well, guess what? That opened the door, didn't it? She was able to go here and have it paid for. She was able to go there and have it paid for. We never did use the word Medi-Cal or insurance once. But because of the instructions from the court and the way we ruled it, we could say that was paid for and that was paid for, but the chiropractor wasn't.
And that also relates very much to what I was saying before about a motion in limine on the ground that there has been the door opened by the plaintiff by using their insurance some of the time and not using it other times. And I do think that David's absolutely correct. We could avoid the use of the I word if we needed to. But before we take our next break, let me just make a couple more comments. Right, that's what I'm doing right now. Thank you. What I'm also doing is I'm focusing on the lien providers, and and those depositions are a lot of fun to take. As I mentioned earlier, doing things like asking the doctor, well, you take Blue Cross, don't you? Oh, yes, I do. Tammy has great questions. Well, do you know what a CPT code is? How much would you have been paid if you had used the insurance in this case? Oh, I don't know. I don't know. I don't know. Really? Well, I do know, doctor. And isn't it true that you would have been paid X amount of dollars? Oh, I don't know. I don't know. It's a lot of fun. But also, I've begun subpoenaing the health insurance policies from Kaiser because, as David noted, and every other policy as well, but good thing to do. But a person, one of our audience members, came up to me during the break, and he said that he recently subpoenaed a Kaiser policy, and Kaiser would not produce it to him unless he signed a stipulated protective order. Did I get that right, Tony?
It was actually the capitation agreement between
Okay. But they wouldn't produce it without an order, a stipulated protective order. And Tony's response was, I'm not going to do that because I think this is going to get me evidence that I can use at trial. And I just gave him a copy of the Dodd case, which I still want back. and I think that Dodd is really going to give him something to work with in this regard.
Can we just, has everybody read Dodd? I mean, I don't want to, it's
We-
late
oh,
on a
it's a
Friday
great
and
case.
eyes get heavy, and I don't want to bore you with Dodd, but this is where Dodd comes into play. And just briefly, Dodd is a case where they had one of these factoring organizations. Essentially, they buy the bill from the medical, and there's a lot of shenanigans in Dodd because it turns out the plaintiff attorney is a shareholder in the organization, and the court ignores politely on legal bases but makes very harsh comments about the possibility of collusion. But what the court said in Dodd was the defense had every right in the world to see the agreements that the medical provider had with this factor agency so that it could assess what the reasonable value of the charges and the services were. Well, in the context of health insurance being out there and a doctor having a health insurance agreement or such with Blue Cross, whatever, it tells me, Dodd says, again, we can err on the court shall err on the side of allowing discovery. And so your subpoena for the insurance policy, your subpoena for the agreement between doctor and insurer are pretty much fair game.
And I told Tony that, and David and I, when Dodd came down, we were doing a little happy dance because we couldn't believe it came down last week as we were preparing for this presentation.
Song giving.
But I told Tony, our audience member, that given Dodd, I wouldn't sign a stipulated protective order because you want evidence. If you assume or hope or have reason to believe that this might lead to relevant evidence of collusion or the value of medical services or whatever, you're not going to want to sign an order saying that you can't do anything with it except look at it. So I would move to compel unless you were able to tailor the stipulated protective order to allow you to use it at trial if you needed to. But one other thing that I think is really significant is that you can meet and confer on these issues. You can do whatever you want to in terms of moving to compel. But at the end of the day, I really think that asking a doctor a question like, this is a Dodd question, and I've added it to my list of questions for lien holders now, lien providers. Dr. So-and-so, do you ever sell your liens for medical care to factoring companies? Do you have any financial interest in any factoring company? Have you ever had any financial interest in a factoring company? Because boy, I really think that when you read Dodd, David summarized it beautifully, but I think that the poor lawyer in that case may find himself on the receiving end of some contact by the state bar court because there is a clear conflict of interest of massive proportions.
So I just want to touch on the meet and confer and move to compel, because how infrequently do we send meet and confer letters and move to compel form interrogatories for their insufficient response? Not for failure to respond, but for the insufficient response. Okay, you got to justify that to the carrier. It costs money to go down the line. Sometimes you're lucky if you get sanctions warranted. I mean, it's just like, it's one of these where we've thrown it out. Well, 4.1 can be very significant, and I would stress to you that if you think you have an argument that there's insurance, and you need to make a pitch to your client, your principal, as to why you're spending the money, the pitch is pretty simple. For X amount of dollars, we may wind up finding out information that could save you 6, 10, whatever that number is, because instead of going after a total billed amount that we know is fake, we can now get and say, you know what, there should have been an insurance payment. So, my associate always comes to me because these answers on the form interrogatories, they're not quite perfect. And I'm like, so what? They're form interrogatories. I'm going to ask somebody questions later. It's not that big a deal. But now I'm starting to rethink this in light of Dodd vis-a-vis the 4.1. I'll take the question in just a second. One last issue on Dodd. Dodd talked about your issue with the stipulated confidential statement, and what happened was the factoring company said this is that their agreement was protected, trade secret, et cetera, but they only made an argument, and they didn't cite any cases or any support, and so the appellate court dismissed that out of hand and said, you know, if you don't provide legal support, we're not considering the issue. So it is a lingering issue, and I think you will have to have discussions about how to do it, and you may have to work with the court in terms of structuring what your protective order may look like.
And just a quick cite, Dodd versus Cruz, 2014, CalApp, Lexus 118. Ooh,
right up there. Question was from the audience. Yes. No, Dodd is only a discovery case. Really, it's only about discovery. And
You mentioned that one thing you do is not only establish that there was coverage, but write a deposition of the legal claimant that is not. But that doesn't really do us any good, does it, when we've got a Kaiser?
well, generally with Kaiser, if Kaiser beneficiaries go out of network, Kaiser will still pay something to the out-of-network provider. And so there's still going to be one of these statements that Kaiser will prepare, and you can still attack it in the same ways. Well, I think it is.
it was a huge argument in my case I made to the jury. That it wasn't on the mitigation issue per se. It was the flavor of the theory of their case that I was able to attack, that, you know, I couldn't get, this was the only person that would provide me immediate treatment.
Right.
And are you kidding me? You can't say that right after you've first been to your Kaiser doctor. Jonathan Lee, question. So I do want to add one last little closing argument for the lien-based provider. And it went something like this. Dr. Chiropractor, isn't it true that you've taken this on a lien? Yes. And doesn't that mean that you're not getting paid until the case is over? Yes. Okay, I didn't raise the contract up, and I'll tell you, plaintiff counsel never raised it, because the contract they had signed with the chiropractor says, I'm entitled to my entire fee regardless of what your recovery is. So they never rehabilitated that statement. In closing argument, the argument was, remember the jury instruction by the court. You are entitled to consider each witness, whether they're truthful or not. You can consider a part, a whole, or none of their testimony as true. And things you look at include bias. And ladies and gentlemen, if that chiropractor doesn't have a bias in the outcome of the case, I don't know who does, because he hasn't been paid yet. And he's waiting for you to pay them before he gets paid. So of course he's going to say everything he needs to say to make you believe that the plaintiff was injured and that his treatment was reasonable and necessary and that his bills were reasonable expenses.
One last comment, sorry. Meet and confer. I've had 2 cases recently with lien providers, and I've met with a plaintiff attorney and said, here's what we're going to do. Here are my motions in limine. Here's how we're going to handle this. Here's what Tammy has told me the case is worth. Here's what Blue Cross would have paid. You better handle this. I said, by the way, you have a couple more months that your lien provider could bill the insurance. You might want to suggest they do that. And I'll be darned if twice they didn't. So that gave me my fee-for-service numbers, and it was a much happier result.
Okay, 3:15, quick break, 10 minutes or so, then we'll come back and we'll wrap it up with Kaiser's consolidated statement.
I hate to dance alone.
You were both very good as far as.
And I wanted to ask it to all of you. Hopefully, all of you are on at least the general listserv to the ADC. One of the grand benefits. Let me talk about a few things. First of all, the question here. So the listserv, there was a statement in the last week about judges down in Monterey not wanting to follow Howell and Korenbaum. I don't know if the person who asked that question is here. What I really want to know is, has anybody had an experience one way or the other down in Monterey? Was that your experience? But your experience was they did not follow Howell? Okay. So just as a reminder, as Mark Bonino has well educated us in the past, in California, unlike the federal jurisdictions, a court is not compelled to not follow something in its jurisdiction. In other words, the 4th District, because Korenbaum may not come out of where Monterey is, the courts in California are required to follow cases even though it may not be a ruling in its district. Right? In the federal system, if you're in the 9th Circuit, the 9th Circuit can ignore the 11th Circuit, and in fact does so all the time. But in California, we don't have that same rule that if you're in the 1st District and there's a 4th District ruling, you don't have to follow it. The courts still have to follow it. So my suggestion is, if you're going down in Monterey, you better paper your file well and make sure that you are preserving your record, which is truly, I think, our primary job as trial counsel is to make a record for the appellate counsel. If you're doing that, you're doing a thorough job. The second thing is I'm going to do a little bit of ADC touting. As many of you know, I'm on the board. I am charged not only with technology platform, but this year advertising, and I've been helping out with membership. And the big thing we started last year, and I'd like to see it gain some momentum, is our March Madness for Membership contest. And we're going to do it again this year. To qualify for the contest, you have to get 3 new members. It's not that tough. And if you're the winner of the contest, you get a new iPad. A suggestion would be, and I don't know, they were supposed to put them in the materials. I'm not sure if they did, but you can always get a copy. In fact, I think our email had it, of the membership application form. And what I say is, take that membership application form, sign your name in the referral box, have someone in your office copy it 5 times, 10 times, whatever, and stick it in your briefcase and take it to depositions, take it to your mediations, whatever it may be. Now, I had made a suggestion about taking it to case management conferences, but then someone piped up and said, who goes to case management conferences anymore? We do those over the phone. And that's true. And today I was at a case management conference, and the number of ADC people that I knew by name that were on the other side of the phone was amazing. So that's our membership. We'd like to drive it up. You can tout them. Hopefully this is a great program, and you can tell them about some of the benefits, including the listserv and our programs and other things. So that's my pitch for membership. Rah, 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 go get us some members.
I want an iPad.
Okay, so this last topic, Kaiser's consolidated statement. This whole presentation really was generated by an email that started on the Howell listserv by, I think, Michael Burke way back in December, and it was, has anybody dealt with the Kaiser consolidated statement? And a lot of people didn't hit reply only to him, but they hit reply all, and said, include me in it too, include me in it too. So when I finally talked to Michael Burke about it, no one had really provided him much information. We do know that someone from Karen Jacobson's office in Sacramento was successful in making an argument, a motion to eliminate or a pretrial argument at some point that said the statement shouldn't come in. The court granted the motion, and the case settled at that moment. So there's something to be said. So I just decided it's time for me to talk about it. So the question is, really, Is Kaiser's consolidated statement an incurred medical bill, or does it demonstrate a reasonable value? There's a few things here. So let me tell you, and now that you're captive and you can't leave, I'll tell you the real clue here. If you go to the back of the materials, and I'll find it real quickly, starting at page 96, in my research, I was able to find a Kaiser plan document pertaining to Stanford University employees for the calendar year January 1, 2014 through December 31, 2014. It's a long plan. It's 89 pages. So I excerpted a few of the pages there at 96, 97, and 98. And essentially, the components that we want to look at are how plan providers are paid. That's on 96. Some of the issues on your cost share, coordination of benefits, and then most importantly, at the back, it should have had third-party liability. At the bottom of page 98, it says injuries or illnesses alleged to be caused by third parties. The last thing I did was I put together a sample motion in limine, 3 pages long. It's got all the sites. Again, I think I'm the greatest researcher in the world, but I hope you don't, and I hope you take the time to go and dig some more, but it's there. I'm going to make a document, a .doc version available on my website, on our website at McDowell Cotter. It will have a password protect on the document itself. If you decide to download it, and it's not available yet, we're having some technical difficulties, just send me a note. But the password protect is going to be Howell, Kaiser, all one word, capital H, capital K. That way you can take it and paste it in, and you don't have to do all the work if you like what I've said. So starting off with some of the cases, and it's interesting because when you do the research on Kaiser, those cases that talk the most about Kaiser as a situation happen to be the cases, and Mark Bonino used to talk about them all the time, pre-Howell, the cases involving the right to victim restitution. So here's what one of the cases said. Inri Eric tells us, it is well known that Kaiser is an HMO, providing medical services to its members rather than a medical service provider with a conventional creditor-debtor relationship to its patients. Kaiser is a capitated plan. Tammy, what's a capitated plan?
A capitated plan is where Kaiser, a good example is Kaiser, and they have where the subscriber pays a monthly fee for their insurance, whether or not they use it or not. It's a prepaid amount that they bill or they pay on a monthly basis. There is no bill that they incur other than, i.e., a co-payment, depending on what their plan is. So there is no bill incurred for their care.
So there's another INRI case, another victim restitution case. This one's KF, and I'm going to just read a few parts from it because it's interesting. It dealt with Kaiser, a consolidated statement, and another component of something Kaiser sent, a letter saying it was services incurred. So listen to the language of the court, though. Apart from the described records, however, the present record is entirely silent on this subject. We are therefore left with the uncontested recital in the quoted document that the victim was billed for the stated amount. What that appellate court said is, counsel, you didn't give us anything to rule in your favor on. And left with a vacuum, we only had one thing, and it happened to be a piece of paper that said billed on it. Maybe underlying that was, hint, 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 we would have liked to go your way, but you didn't give us anything to do it. Okay? The second quote that I liked from INRI KF really goes into what we see as counsel. The other document challenged by appellant is an explanation of benefits from Kaiser, apparently reflecting the value of the ambulance service provided. It lists $582 in ambulance charges. It also describes this sum as the amount charged. But it bears the prominent legend, this is not a bill. It shows zeros in the column marked coinsurance copayment. There is no entry in the column marked amount paid. and in the space marked your obligation appears the sum 0. The court denied restitution on the ambulance bill. So this court told us that if you do the right record and give us the right information, we may actually determine in the restitution context that nothing was incurred. So what is Kaiser? Well, that well-known encyclopedia on the internet called Wikipedia tells us that Kaiser Permanente is an integrated managed care consortium. It's made up of 3 entities, and I didn't know this until I looked this up. There's the Kaiser Foundation Health Plan, which is the insurance part of it. The insurance part of it is a nonprofit. There are Kaiser Foundation hospitals, which are the hospital providers, and then there are the doctors that make up the Permanente medical groups. They are actually for-profit providers. Okay? When we see a consolidated statement, one has to ask the question, is this statement coming from an insurance company? If so, it ain't a bill. Is it something coming from just one of the providers? Or does the word consolidated suggest to us that it's a mishmash of all kinds of information? And Tammy, I'm going to ask you, and if we don't get to it, then I want you to tell us a little bit how you understand the Kaiser and the healthcare recoveries to come up with these bills or these consolidated statements. So in the health plan document, remember now that we've talked about Dodd, we're going to subpoena these things. It says to them, the members, how plan providers are paid. The plan and plan providers are independent contractors. They are paid in a number of ways, such as salary, capitation, per diem rates, case rates, fee for service, and incentive payments. Is one of those things on the consolidated statement an incentive payment? Does that suggest reasonable value? Question. So what I also thought was interesting, which plays right into Dodd, is it tells the plan members in the next paragraph to learn more about how the physicians are paid, please ask your physician or call our service center. Well, the way I do that is with something called a subpoena. And Dodd tells me that it's okay to go after and use that subpoena and go find out that information. So when we're dealing with this and we're talking about reasonable value, Tammy, what is the expert attack on this?
I think there's several different ways that you have to approach Kaiser. What I see is, number one, you have to find out what the lesser of paid versus reasonable value is. And just as a side note, I think I was telling you that I do both sides. And I just had a deposition in Las Vegas last week where a health carrier had paid $212,000 out of $300,000. The health carrier was going against the claimant because they had received a settlement of $600,000 for getting that money back. Based on my methodology, the reasonable and customary price that the health carrier should have paid the hospital was $40,000 to $60,000. I did that 5 different ways. At the end of a 2-hour deposition, the defense attorney said, it sounds like we better ask the hospital for our money back. And I said, that's what I said at the very beginning. Anyway, what I want you to do is use ChargeMaster to compare. If you don't have the medical bill or a statement of benefits, which to me is sometimes a bunch of hooey, but is if you have to look at the medical records, is I call it reverse engineer the medical bill. And this means you don't have anything from healthcare recovery, so you have to look at the medical records, apply CPT codes, and then run it through reasonable and customary. I like to review the healthcare recoveries bill. To me, it's a statement of benefits, all the things that David has brought up and Shauna have brought up. To me, it's really not a bill. Most treatment providers' bills are at least consistent in what they bill for a CPT code. And I will look at a healthcare recoveries bill and I will see that on one day of service, they might bill $30 for a chest x-ray, which is below the reasonable and customary value. But 2 days later, they're billing $300, which is above. So to me, their methodology makes no sense at all. And that's what I really try to push for you to ask. And so that's why I've come up with the PMK questions that you have in your packet. And if you want a copy of the regular PMK questions or trauma team questions, let me know. And then I also have the information for the California Charge Master website. And I think, Shauna, what I thought was really great is I was telling Shauna that, you know, you can hire your paralegal to do a lot of this stuff for you. And it,
Oh, yeah. Can I say that?
Yeah.
All right. Tammy and I have had some cases together involving enormous hospital bills. You know, the kind of hospital bills that total up to $500,000 or $600,000. I have been designated as an expert in several cases and continue to be where Medicare is at issue, where an insured Medicare beneficiary has sought care through a lien provider. And in those cases, I have gone through the Medicare resources, the Medicare reimbursement resources that Tammy has discussed, and I have done the line by line by line by line by line. Even when you get a flow going, it is an extremely time-consuming process. And I had to tell my client this is going to be thousands of dollars, but it's necessary. We ended up being able to reduce the bills to something like $90,000. But the next time I had a case, I gave it to Tammy. And I was happy to see that it took her a lot of time as well, but she did it much more quickly because she has her husband to help her. She has staff who are devoted to this process. And I was probably the most knowledgeable person. There's one paralegal in my office who were the most knowledgeable about how to do this ourselves with Medicare. But it is a cost, it's a time-consuming process, but I think it's absolutely invaluable. I think we have to start doing it.
So I just wanted to confirm whether I'm right or wrong. So first of all, guys, remember with the Kaiser Consolidated Statement, it's usually mailed from somewhere on the East Coast like Louisiana. And my understanding of the way that healthcare, the Tricor Healthcare Recoveries creates this thing is that they actually create it. So remember, that starts asking us hearsay issues. And what they do is what Tammy's talking about. They try to reverse engineer the medical records, figure out what the procedure code would have been, and then apply that procedure code and create this statement. Then they attribute some numbered dollar value to that code. And if I understand it right, you could get from the same, quote, hospital treatment, two different numbers because they don't really know what their numbers are doing. Is that an accurate?
that is correct. And, you know, like I said, you've got the information for the, especially like inpatient, where you can do to the California Charge Master, and you will see where they do not know how to bill.
You know,
And
and Tammy has acquainted me with the concept of bundling, because there are specific way, billing is a very, very, very specific process. And if you don't do it the way a particular insurance company requires it, they will reject the bill. And if it's not done that way, I get bills from Tammy where she says, nope, we're allowing $0 for this because it wasn't done properly.
I mean, there are specific rules for billing and coding, and I'm not making up the rules. Go ahead, yes.
I've always been very nervous about using card management just because I figure this could be anything. This could be their billing procedures, and somebody's going to pop up on the other side who really understands this and they look like a total bitter. But that hasn't happened to me.
No, and what I have found,
It really is incompetence. It's just not so bad. It looks like incompetence, but then I think, wow, maybe it's really sophisticated system. Maybe this is the bill when there's high demand, and this is the bill when there's low demand. That's why there's a discrepancy.
it is total incompetence. When I had a small company before I sold to a national company, the one thing I was going to do, because I think nurses have as much value as physicians, the one thing I was going to do was go after the Kaiser contract for creating the bills, because I know what I'm doing. But healthcare recoveries, I mean, you can call them, and if you pay that day, they'll offer a 50% discount. I mean, so what provider is going to do that on the first day? I'm just saying that healthcare recoveries, and I would say it if they were sitting here, does not know what they're doing. And I would love to, if you get some of these, you know, you've got the PMK questions, I would love to hear from you what you find out when you do some PMK questions.
There's a question in the back. I've got about 15 minutes or so, so maybe we can hold the question until the end, and then that way I can get through the material. I got Andy and then this gentleman way in the back. So what's the defense attack? Okay, my attack is what I learned from the Jacobson law firm and what I tried that I politely lost on up in Sacramento, which is you need to make a motion to eliminate to preclude the introduction of that statement and hopefully preclude the information at all from coming in. And again, that depends on your discovery. So remember this on your motion. First of all, it's plaintiff's burden to demonstrate the reasonable value, okay? So it's up to them to provide the information, to have the evidence, and through your discovery, for you to assess whether they have sufficient evidence to carry their burden of proof. Secondly, the statement itself, whether it's a bill or in this case, a third hearsay, is a hearsay document, okay? Invoices and accountings received from third parties are hearsay. There's your first objection. There's a case called Pacific Gas versus Thomas G.W. Thomas. Invoices may be admitted for the limited purpose of corroborating testimony if the charges were paid. Mr. Plaintiff, in deposition, did you make any payment? I paid $5 copay. Have you ever seen this statement before? No. Have they ever asked you to pay it? No. Okay, the plaintiff can't bring it in now because he can't corroborate it. Remember also that even if we want to get it, if they want to get it in because maybe they get it around on a limited instruction from the hearsay rule because it's corroborative. As State Farm versus Huff tells us, citing Korenbaum and Howell, the full amount billed by medical providers is not an accurate measure of the value of the medical services. Okay? For a variety of reasons. So it's another reason to keep it out. Under the case that I cited earlier, plaintiff will not be able to demonstrate that the amount was incurred. Again, it's incumbent upon you, as we saw counsel not doing in the appellate record, you've got to do your discovery to make your record. You've got to make your record to support your motion in limine. So again, it goes back to those questions. And as Tammy says, you may need to go and take depositions of persons most knowledgeable at Kaiser. Someone was telling me recently, they took the deposition of the doctor, and, I did it too in the case that I was telling you about. I asked the doctor at the end, "Doctor, do you know anything about how much you're charged?" "No." "Do you ever see bills?" "No." "Do you ever have anything to do with bills?" "No." Well, there you go. The treating physician can't talk about the billings now. The plaintiff, another argument, the plaintiff cannot demonstrate that the statement reflects the amount paid to providers. Remember what I said about what the plan documents say in the variety of ways the medical care providers and or the hospital are paid. Okay, some are paid just a straight salary. Some are paid on a capitated. If you can use the plan documents to establish the variety of payments and then take depositions of a billing department person, and if you want to go to Louisiana and you're paid to do it, take the deposition of people out at healthcare recoveries. Again, that's a way to build this next argument in your motion in limine. I raised this question of the lien does not equal the amount incurred because that's exactly what they threw at me at trial. And with that in mind, I'm going to just kind of recap the way the judge and I had our conversation. The judge said, they said there's a lien. And I said, well, Judge, this lien is governed by Civil Code 3040. And the language of Civil Code 3040 is at page 103. And Civil Code 3040 allows a health insurance plan to seek reimbursement by way of lien on a judgment or settlement or to subrogate, but it can only do it by the amount circumscribed in this statute. So I said, Judge, they may have a lien, but first of all, the lien has got a mathematical formula, and we don't know how that formula is going to work out because we need to have a judgment. And one of the things it says at subpart B of 3040A, or subpart 2, excuse me, for health care services provided on a capitated basis, the amount equal to 80% of the usual and customary charge for the same services by medical providers that provide health care services on a non-capitated basis in the geographic region in which the services were rendered. So if I give the jury this $1,000 statement right away, the other part that's not in here that makes the math more important is that the plan cannot recover any greater than the lesser of 1/3 if they're represented by counsel, 1/3 of what their capitated amount is, or the total lien. Okay, the lesser of. So if I've got a $1,000 bill, let's just use even numbers, and it's a $2,000 settlement, they don't get their $1,000. They get 1/3 of the $2,000. That's the most that they can come back and get. If it's a $3,000 settlement, then yes, they get their $1,000. But here's the issue. At trial, I don't know what that number is. No one knows what that number is until the jury comes back. So to say that it's incurred because they're a lien is false, and it is confusing, and it can open up a whole can of worms. Now, Judge Abbott and I had a disagreement, and as I said, I won my Howell motion, so I wasn't going to push the issue too much. But again, it's a complex formula, and this concept that they have a lien, therefore it's incurred, really, to me, doesn't fly, because we don't really know what that lien amount is. Yes, Your Honor, they have a lien. Then let's all figure out what's that actual amount, because what we want to be able to do is present to the jury the amount incurred. And we don't know what's been incurred until we know the judgment. It's, the chicken or the egg. By admitting the Kaiser Consolidated Statement, are we not violating the collateral source rule? Are we not telling the jury that there is insurance out there? Okay? Korenbaum tells us the evidentiary aspect of the collateral source rule makes evidence of collateral source payments inadmissible. This precludes evidence that an insurer or another source independent of the tortfeasor paid for the plaintiff's medical care. Well, we know that Kaiser is telling us in their documents that somehow they're paying the providers, but does not preclude evidence of the amount that a medical provider pursuant to prior agreement has accepted in full. So again, in our trial, we never once mentioned the word insurance. What we mentioned was that bill was paid. We don't know if those bills have been paid because we don't know, pursuant to that plan agreement, we don't know what the agreement is. They may all be on a salary for all we know and never get paid anything. So again, you need your discovery. Another argument in keeping that thing out is the collateral source rule. I think I have a series of other arguments in here, but those pretty much summarize them. As my father said, because he used to write a lot, he is his favorite author, and I am my favorite author. I love what I wrote. I hope you do too. Let's go back to the defense attack. Finally, remember your discovery. Take those criminal restitution cases and use them as a guideline for what you need to do to support your motion to eliminate. Remember form interrogatory 4.1, and please make them answer it. Request for production of documents. Get a copy of the plan documents from the plaintiff. Take depositions of person most knowledgeable at Kaiser in their billing department and wherever else you can find the people. When you take the deposition of the treating doctor, establish that they have no knowledge of the billing, how it's done, whether it's paid, if it's paid, any of that information, so you knock them out of the opportunity to say this was a reasonable value for her services. Get someone like Tammy if you need to, if the dollar value is great enough to worry about it, to figure out what the reasonable value is. You may want to use this person in the capacity of Tammy as a consultant, right? I'm of a mind, I like to hire my consultants early on in the case. I know that carriers are against that. It costs money. Again, it's the issue of what's your return on investment. If I can get information out of my consultant and know that before I have to disclose and use that information to ask the right questions and propound the right discovery, I think there's a value added. But you got to be an advocate for the cause. Do you have your slide sheet?
Yeah.
I want to just flip it. I just want to see where I am. One more time. Okay, and as I said, use a billing expert. Oh, one last thing. The reason that the Jacobson office won that, at least my understanding from the attorney I talked to, was they never disclosed a billing expert. The plaintiffs did not. And so they had no one to come in, and what they were able to do was fight the battle on incurred, and when there is no incurred, and then leave it to the second part of, well, now court, the only thing left is for them to establish the reasonable value. They've not disclosed an expert on reasonable value, therefore they can't make their case on that. The court granted it, and guess what? I mean, unfortunately, he lost a trial, but you can do your client no better than by winning it and avoiding that 5 days of trial and winning it on the motion in limine to knock out the key part of their case. So that's why I think the motion in limine, 2 brackets, right? The reasonable value aspect is the expert aspect, and what's the incurred amount, and there's a lot of stuff we need to get incurred, is how you tackle this thing called the consolidated statement. So it's 4 o'clock. I'm going to leave you guys. Oh, the questions. We had a question in the back.
Realistically, what happens when you do the PMK at Kaiser? So you ask somebody's produced the billing person at Kaiser, they say, well, we don't come up with any billing, we send it to healthcare recovery. What, do you end up back in Kentucky? Or do they send somebody from healthcare recoveries out to be the PMK? Or, I mean, really, what happens?
I don't know. Has anybody experienced that?
I have had the experience of noticing a PMK of Kaiser, and please remember that the PMK is supposed to be the person most knowledgeable about what the issue is that you're discussing. They're supposed to produce somebody who knows how those medical bills were arrived at. If they don't, then I would immediately end the deposition and seek sanctions for not producing a person who's responsive to the notice. But I do think that if we continue or really focus on trying to get the depositions of PMKs of Kaiser, for one thing, we will get largely inconsistent information, I'm confident, about how these numbers are reached. I don't think they have a consistent plan. I don't think there's a single document. And I also look forward to speaking to Kaiser doctors and asking them how they're paid. Because even though the document David read talks about all these multiplicity of ways that they're actually compensated, I bet you 99% of them are flat rate employees. And I think we all know that. They just do whatever comes in the door.
So I would question then Andy, but I want to make a comment, which is there's a reason why we've got the listserv, guys. If you happen to get that kind of information or have an experience, share it with the rest of us, because then we can build on this. And we can build on our cases when they go on appeal and use the amicus component of the ADC to advocate these positions. It's really important to build that. There was a question at mid-level in the back. Okay, the hand didn't go up. Andy's hand.
I'm just going to make a comment.
Yeah.
I'm a Kaiser patient myself, and when I go in for office visits, lab tests, or whatever, usually a month or so later, I'll get a statement from Kaiser. Even though I just paid my copay, they will place a value of the services I've rendered, acknowledge my copay, and say I owe zero.
Okay, so what Andy, for you guys in the back, Andy's saying is as a member of Kaiser, when he goes in for anything, he actually does get some form of a statement of the services. And did you say that they assign a dollar value to it? And they assign a dollar value. So
Which group are you a member of?
It's president of the Northern California region.
Because do you know what category of Kaiser is it an independent permanente medical group?
Does it come from the insurance side, or does it come from the medical side?
It comes in my mailbox.
it comes from the U.S. Postal Service. All right, question.
No, because I think the issue there is going to be that's fascinating.
Yeah,
I bet you
yes.
Tammy's fascinated to hear
I
that.
want to hear.
Because I'd like to see some copies of that. You can redact all the fun information, but but no, I think that flies in the face of our understanding that they prepare these consolidated summaries.
I think that's an explanation of benefits is what he's
I agree.
and that's probably coming from the insurance side.
I think that's
Right,
great.
And remember what the In re Jeff case said about the explanation of benefits. It didn't satisfy it. Question over here.
Not a question, but there's an interplay between Kaiser and Medicare, which I had, which is under certain Kaiser plans, if the person was a member of Kaiser before they turned 65, then they're not covered under Medicare. Okay? I had this come up because we had to chase Medicare to get them to state affirmatively that there was no Medicare lien or claim because of this particular Kaiser plan. And one of the problems was that even Kaiser couldn't produce the plan said, yes, we're not, no, there's no Medicare claim.
You know, this may be the case that I have. This may be the case that I have. That may be the explanation. But I'm going to find out because, I mean, I'm really going to find out because it's just not acceptable for them to say, oh, somehow through some magical process, this person who otherwise would have been Medicare and Kaiser would have been Part C just continues to be Kaiser. Because I just, that's not the way it should work. It's crazy. I know that you can't find anyone to tell you anything.
All right. So if you have further questions, why don't you come up and talk to us? Before we go, though, I want to leave you with this last thought. With the Affordable Care Act now, everybody's going to have health insurance. Number one is if you get a 4.1 interrogatory that is answered no, something fishy going on. Number two is Howell gets played out in spades now in California because there is always going to be a negotiated rate differential which lessens the amount billed to a lower amount incurred. Thank you, everybody. Appreciate it. Oh, and thank you to Liberty Medical for sponsoring.
Yay.
Do appreciate it.
And reception follows.
Yes, cocktails outside.
Let me see. Let me just give you a cocktail time.
Yeah. Please. Uh-oh. Yes, that's incurred.